We will hear argument first this morning in Case 23-334, Department of State versus Muñoz. Mr. Gannon.
Mr. Chief Justice, and may it please the Court. Last fiscal year, the Department of State issued 11 million immigrant and non-immigrant visas. It also refused 62,000 visa applications on the basis of one or more of the admissibility grounds in 8 U.S.C. 1182A, including applications from approximately 5,400 non-citizens seeking to live with their U.S. citizen spouses or fiancés. Under the doctrine of consular non-reviewability, a non-citizen outside the United States cannot obtain judicial review of a consular officer's denial of a visa. Congress has not provided for that form of review in the INA, and when it added new visa-related provisions in 2002, it reaffirmed that it was not providing an end run around that. Nor is an end run available when a U.S. citizen family member, here the non-citizen spouse, wants the non-citizen to be admitted into the United States. As the Kerry against Dinn plurality concluded in 2015, that is not a liberty interest protected by the Due Process Clause, and the U.S. citizen is affected only indirectly by the government's action against the non-citizen. Thus, Respondent Muñoz cannot challenge the denial of her husband's visa application any more than she could challenge a decision at the end of a removal proceeding that he will be removed from the United States, or at the end of a criminal trial that he would be sent to a prison far across the country. With respect to the second question presented, even assuming that Respondent Muñoz has a sufficient constitutional interest to trigger any judicial review, the Court should at the very least hold that the State Department satisfied the Mandel standard. The consular officer provided a facially legitimate and bona fide reason by citing a valid statutory ground of inadmissibility, the unlawful activity bar, just as Justice Kennedy's concurrence had found had been the case in Dinn, where the government cited the neighboring terrorist activities bar. I welcome the Court's questions.
Just for clarification, assuming that Ms. Muñoz does in fact have a liberty interest, would the consular non-reviewability preclude her winning here?
We think that it would. We think
and
that
how would that work then?
The only potential exception there would be if there were a constitutional right that this Court has recognized. That would be the only potential exception. We otherwise think that the point here is of consular non-reviewability is that the person whose interest is directly at stake doesn't have a right to review, and a fortiori, it seems that somebody who is only indirectly affected by the government's decision in that proceeding also cannot challenge that. And so the second question presented, assuming that she has a constitutional interest, would be that we at least satisfy.
Well, I understand that. I'm just trying to figure, without even getting to Dinn, whether or not reviewability, non-reviewability would preclude any her having any recovery at all whatsoever, that you wouldn't even have to get to Dinn.
Well, the case has been litigated on the presumption that there would be an exception to consular non-reviewability if we were to lose on the first QP, and that's what Justice Kennedy's concurrence said in Dinn. I don't know what the cause of action is that she has in order to bring that. The Ninth Circuit has been assuming that there is one, I guess, under the Constitution. We think there is not one under the APA, and none of the courts of appeals has found that there is one there, and so we think that there still would be reasons to say that there isn't going to be any review even in those circumstances, but at the least we would satisfy Mandel.